Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements, arguments, and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of any evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You have heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard from several expert witnesses. Zachary Batchelor has given you his opinion as an expert in the field of video technician and audiovisual analysis. Dr. Stephen Cole has given you his opinion as an expert in the field of forensic pathology. Brian Childs, who has given you his opinion as an expert in the field of taser and body cam by Axon. Seth Stoughton, who has given you his opinion as an expert in the field of use of force and police practices. Nicholas Bloomfield, who has given you his opinion as an expert in the field of police practices and use of force. Captain David Siver, who has given you his opinion as an expert in the field of GRPD training policies and procedures. Captain Chad McCursey, who has given you his opinion as an expert in the field of GRPD training policies and practices regarding taser use of force and duties and functions. Lon Bartel, who has given you his opinion in the field of exercise, sports science, and exertion and exhaustion factors. Dr. Mark Kroll, who has given you his opinion in the field of operations and effects of electrical weapons. Bob McFarland, who has given you his opinion in the field of video analysis. Jason Getty, who has given you his opinion in the field of GRPD firearm training policies and practices. David Blake, who has given you his opinion in the field of human factor psychology and police practices. And Von Kleem, who has given you his opinion in the field of police practices, tactics, policy, and use of force. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they gave for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, That is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial a witness made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. The defendant, Christopher Schurr, is charged with the crime of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya. That is, that Mr. Lyoya died as a result of a gunshot wound from a gun fired by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The prosecutor must also prove beyond a reasonable doubt the crime occurred on or about April 4th, 2022 in Kent County. You may also consider whether the defendant is guilty of the less serious crime of voluntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya, that is, that Mr. Lyoya died as a result of a gunshot wound fired from a gun by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the defendant caused the death without lawful excuse or justification. The crime of murder may be reduced to voluntary manslaughter if the defendant acted out of passion or anger brought about by adequate cause and before the defendant had reasonable time to calm down. For manslaughter, the following two things must be present. First, when the defendant acted, his thinking must be disturbed by emotional excitement to the point that a reasonable person might have acted on impulse without thinking twice from passion instead of judgment. This emotional excitement must have been the result of something that would cause a reasonable person to act rashly or on impulse. The law does not say what things are enough to do this. That is for you to decide. Second, the killing itself must result from this emotional excitement. The defendant must have acted before a reasonable time had passed to calm down and to return to reason. The law does not say how much time is needed. That is for you to decide. The test is whether a reasonable time passed under the circumstances of this case. The defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. You may return a verdict of guilty of the alleged crime, guilty of a serious crime, or not guilty. The defendant claims he acted in lawful self-defense. A person has the right to use force or even take a life to defend himself under certain circumstances. If a person acts in lawful self-defense, that person's actions are justified and he is not guilty. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. At the time he acted, the defendant must have honestly and reasonably believed that he was in danger of being killed or seriously injured. If the defendant's belief was honest and reasonable, he could act immediately to defend himself, even if it turned out later he was wrong about how much danger he was in. In deciding if the defendant's belief was honest and reasonable, you should consider all the circumstances as they appeared to the defendant at the time. The relevant consideration is not what the defendant should have known or done, but rather what a reasonable officer with the knowledge and in the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. Reasonable is that which an ordinary, prudent, and intelligent person with the knowledge and in the situation of the officer would have deemed necessary under the circumstances. A person may not kill or seriously injure another person just to protect himself against what seems like a threat of only minor injury. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all the circumstances, the condition of the people involved, including their relative strength, whether the other person was armed with a dangerous weapon or had some other means of injuring the defendant, and the nature of the other person's threat. At the time he acted, the defendant must have honestly and reasonably believed that what he did was immediately necessary to prevent death or great bodily harm to himself or others. A police officer in defense of himself or others may use that force which is reasonable under the circumstances. Unlike the private citizen, a police officer, by the necessity of his duties, is not required to retreat before a display of force by his adversary. If an officer is authorized to arrest or detain someone and the person resists, the officer is entitled to use a reasonable amount of force to overcome that resistance. Like the private citizen, a police officer must reasonably believe himself to be in great danger and that his response was necessary to save himself from that danger. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt the defendant did not act in self-defense. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room to deliberate, you may now take your notes and these full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you will be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing to my clerk. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. That concludes my final instructions. We'll now pick 2 individuals that will be alternate jurors. So what that means is for today, you are excused. However, you still have the same restrictions as before. I'm going to ask those 2 individuals to leave your notes in here on the chair, and we'll make sure they're destroyed in the event that you're not needed as an alternate juror. But it's still for you, again, to maintain the restrictions as before, not access any news reports or discuss the case with anyone, because if we need to call you back as a juror, obviously if you've been out posting on Facebook about how you were a juror and all that, then you wouldn't be much use as a juror in the case. So those 2 individuals will still be, again, under the same restrictions, and then we will follow up and let you know when a verdict has been reached, so that you know that you are discharged, whoever those 2 people are. And I'd also like to take this time to thank those 2 individuals for your time and attention for this case.